Welcome to the Attorney Post, your source for inside baseball talk about the legal field with the top attorneys in the country. Here's your host, Justin West.
All right, and I think we're live. Hello and welcome to the Attorney Post. As a reminder, if you don't know your rights, you don't have any, and that's why we're here bringing you interviews with some of the best lawyers in America right now who are on the cutting edge of law. I'm really excited today to be talking with Sam Tabibian. He is a member of the Century Park Law Group out in California, and he practices a lot of injury law. We're going to be talking to him today about a number of things, particularly automobile injuries and premise liabilities. A lot of people get hurt. A lot of people get injured, and they want to know what their rights are. Your insurance company is oftentimes not looking out for your best interests, and it's injury attorneys like Sam that are out there looking out for you and making sure you're taken care of. So in a minute here, I'm going to give you an introduction to Sam, and then we'll get into the interview. But as always, we're going to start with a word from one of our sponsors. And I'm actually going to jump over here first. So this is Sam's Law Group. That's centuryparklawgroup.com. Again, that's centuryparklawgroup, all spelled out, .com. And you can see they actually boast, we'll talk about this in a minute, a 99% success rate, which is pretty darn amazing. So that's awesome. So here is our first sponsor for the day, and appropriately it is actually for injury attorneys. That wasn't planned out. It's just our sponsor for the day. Our first sponsor is injuryattorneyleads.com. If you are a personal injury attorney, you know that regularly spending lots of money on advertising can get very expensive, but most of the time you get lackluster results. You can spend between $100 and $500 per lead and still wind up getting leads that are not qualified if you ever even get a hold of them in the first place. Oftentimes you can burn through 5 or 10 just to get one serious prospective client on the phone. The solution is injuryattorneyleads.com. Injuryattorneyleads.com has people reaching out to them all across the country who have been hurt in usually motor vehicle accident. Once they fill out a form, that's where most lead companies stop, but injuryattorneyleads.com is just getting started. They reach out to every single person who fills out a form and re-verifies their information on the phone before live transferring qualified individuals directly to your firm over the phone. These are only people who have been in an accident and want to talk to a lawyer about their case. You can be sure that these potential clients meet your criteria for a qualified lead, and the close rates average 60%. You can set up a time to talk with a client generation specialist by visiting injuryattorneyleads.com and clicking on any of the buttons to schedule time. Again, that's injuryattorneyleads.com. All right. And I am joined with Sam Tabibian. Sam, how are you doing today?
Not bad. Yourself?
Doing good. So Sam, I'm going to give a little bit of bio of you here. You are one of the co-founders of the Century Park Law Group. And again, that boasts a 99% success rate, which is awesome. If I understand correctly, you were raised in Southern California in a family of physicians. So you're the black sheep of the family, I guess. I don't know. You went into law instead of medicine.
Apparently so, but none of them were upset about it. Apparently it's easier to be a lawyer than a doctor.
Yeah, there you go. It's still a great field to be in. So during his childhood, Sam saw countless injured patients walk through his father's and his uncle's medical offices. Having witnessed patients suffering through injuries from no fault of their own, Sam began his path to law school. Sam graduated from Loyola Marymount University with a JD and an MBA in 2004. After graduating, Sam joined a prominent California firm that focused on civil litigation. Frustrated with the types of cases he worked on, in 2008, Sam started his own practice focusing on personal injury, business litigation, and real estate litigation, largely representing plaintiffs in complex cases. And in 2013, Sam co-founded Century Park Law Group, a firm dedicated to representing plaintiffs in personal injury matters. Sam also has utilized his MBA from Loyola Marymount to manage Century Park Law Group and to help obtain excellent results for his clients while finding new and innovative ways to use cutting-edge technology in the firm. So question number one I always ask, Sam, is what did I miss?
I think you pretty much nailed it on the head right there. You got everything covered.
Awesome. So you guys do a lot of personal injury law. I know that you specialize in auto and premise liability. We're going to talk about that in a minute. But one of the things that I actually pulled from your website was the tail end of that bio, and you talked about using cutting edge technology in your firm. Something that a lot of people have questions about, especially in the era of COVID, is how lawyers are adapting. So what kind of special technology do you guys use in the process of helping your clients?
So when we first started the firm in 2013, we were lucky enough to start from scratch. We didn't have to have any bad habits. And the first habit that we started out with properly was we were a paperless law firm. Everything we do is digital. So we can access our files literally anywhere in the world. Even when I'm on vacation, I can sit on a laptop and handle any case for any client right off the bat. We also have a case management system in place where we can monitor all the files and make sure we calendar everything and do everything properly in that respect. So because we were prepared properly when COVID hit, we were literally able to shut down the firm overnight, have all our staff work from home, and just open up their laptops, and we were fully functional. We didn't skip a beat as a result of it.
That's awesome. I've talked to a number of attorneys, and they've all shared similar issues. A lot of them share similar concepts. So one question I want to talk to you about, and maybe I should come back to this. Well, I'm going to talk about it now because this is something I'm really fascinated by. I was talking to an attorney the other day, and he mentioned the fact that he thought most of the changes that came about because of COVID were very, very positive. But he said the one place that Zoom can't replace, and I love Zoom. I do a lot of conversations on Zoom. We're talking on Zoom right now. And he says there's this move towards Zoom litigation and Zoom trials. And he says you'll never be able to replace an attorney in the courtroom because there's things that happen live that you can't do. For instance, again, just getting started, we talked about making eye contact, et cetera. And of course, on a Zoom call, eye contact is looking at a little dot on the screen. And sometimes someone in the prosecution will make a statement that will make you roll your eyes. And if I understand correctly, it's very common to look over at someone in the jury, give them a sideways glance, and they kind of give you a glance, and you just know you're on the same page, but you can't do that via Zoom. So what are your feelings on the concept of Zoom litigation? Do you think this is something that just will never, ever happen? Do you think that we may move that direction in the future? What do you think?
I think it depends on the case and the situation. When dealing with a jury, I would agree. I would not, I would never opt for having a jury on a Zoom call. When dealing with a judge, if it's just, most judges are sophisticated, so I don't think it'll affect the case. Personal injury cases, car accident cases, slip and fall cases, we always want to have a jury. So I don't see the future being Zoom trials. I do see us continue to want to go to court. And there's an emotional component that's missing on Zoom. When your client comes into court, if you put your client on the stand, there's a different feeling when you're in the courtroom. The jury feels that, the witnesses feel that, everyone feels that. There's a seriousness involved in it. When you're in an office, in a conference room, in Zoom, you kind of lose that, and the sympathy is gone. Our jury may not understand how injured our client is because you have this medium that's just not able to get that message across. So, while we're dealing with COVID, we got to do what we got to do to get justice for our clients. So we can't stop that, but I would personally opt against going for a jury trial if we don't have to. I mean, going for a Zoom trial or jury trial or Zoom if we don't have to.
Gotcha. That's kind of it's kind of the answer I expected, but you just never know. And I always like to get people's takes on that. Have you had any issues? I know that California is one of the few states that doesn't allow Zoom notaries. Do you ever run into issues where you have to deal with a client who doesn't want to come in because of COVID? Or has that kind of been a thing that's really been a non-issue for you guys?
Most of the things that we deal with don't require notaries. And the clients that do have come in, they've come in for depositions. We set them up in their own office. We give them the same iPad that I'm using for the Zoom phone call right here. And they do it right here in our conference rooms, and they're kind of secluded, so we don't have to worry about the COVID issue. Gotcha. So it hasn't really been much of a problem for us so far.
That's good to know. So you guys do a lot of different stuff. Obviously, I know a lot of injury attorneys cover a lot of areas, from car accidents, bicycle, bus, taxi, train, et cetera. You said one of the things that you like to focus on is both automobile and premise liability. Let's talk about auto for a minute, because I actually have worked with attorneys in other states that do a lot of stuff, particularly with like Uber and Lyft. Apparently there's a lot of people who are driving for those companies that don't have the same kind of professional training that like a regular taxi driver would have. I don't know the ins and outs and how that plays out, like let's say in California versus say New York, but what's been your experience with those sorts of companies? Is that a burgeoning area of law practice, of injury law practice, or is that just kind of an occasional incident?
It's definitely a burgeoning area because there's a lot more rideshare cars out there on the road. There's a lot of people doing it. Mm-hmm. I do actually find it a little bit advantageous for everybody because there's insurance coverage when you're dealing with those cases, and the insurance coverage is not minimal. They're high limits of coverage. One of the issues that we have in California is we'll oftentimes have clients that come in and they're greatly injured, but unfortunately the person that caused them the injury doesn't have any assets and doesn't have a big insurance policy. So they might have $100,000 in medical bills, but the defendant just doesn't have the money to pay. up to that $100,000 mark. Fortunately, with rideshare issues, if a rideshare, an Uber driver injures our client, we know there's a strong insurance policy there to cover the claim. Likewise, vice versa, if one of our clients is actually a passenger in a rideshare vehicle, they have what's called uninsured or underinsured motorist coverage, usually up to $1 million. That would cover our clients' claims as well. So I think it's extremely advantageous that we have these cases now, because it protects the public, it protects the people, because there's a lot more insurance coverage to cover them.
Gotcha. So a question that I did get actually from somebody earlier, we don't have live chat today, but one of the questions I did get is, what do you do if someone is injured, but the people that injured them, they have no resources, they have no money? Are those people without hope? Are there other options? What do you do in those situations?
Well, the first thing we do is we look at our own clients' insurance policies. Many people have what's called underinsured and uninsured motorist coverage, which means if the opposing side, if the person that caused the injury doesn't have insurance, your insurance will cover the claim. There's different limits as to how much they would pay. That's something you would purchase when you get your insurance policy. So usually it's a $25,000 policy or a $15,000 policy, which means if the other side doesn't have insurance, your own insurance would cover you to that amount. On the flip side, sometimes you have a scenario where the other side has insurance, but it's just not enough. In California, the minimum insurance anybody's required to have is a 1530 policy, which means the maximum they'll pay per individual is $15,000 or $30,000 per accident. Well, some people get in accidents that obviously have a lot more value than $15,000.
Yeah, it's like one day in the ER.
Literally.
Yeah.
I mean, it's probably 1 hour in the ER, to be honest with you. And if your insurance policy has underinsured coverage and you have a high limit of, let's say, $100,000, well, you can get the $15,000 from the person that caused the injury. And then you can go after your own insurance for the balance. So if your insurance limits are $100,000, you can get that $85,000 from your own insurance company. It's a very valuable tool. Unfortunately, many people are not educated about it. They don't know that they should get the coverage. So we have oftentimes a lot of clients that don't have that coverage. And the alternative, if our client doesn't have that coverage or doesn't have sufficient coverage, we look to the defendant and we look at their assets. We conduct a preliminary asset search. Regardless of whether somebody has insurance, they're still responsible under California law. So if somebody has a low insurance policy limits, but we know they're a millionaire, we're going to pursue that person and get them to pay out of pocket because our client deserves justice. We're going to get them paid with their value in their cases. And oftentimes we'll get to the situation where there is no insurance, the defendant doesn't have any assets. And unfortunately, there's not much we can do in those situations. As hard as we try, it's just bad luck, I guess you could say, in those situations.
Gotcha. I know one of the things with personal injury law that's really important is acting in a timely fashion. I know some states have really, really short statutes limitations of when you can, raise an issue. What's the statute of limitations in California? How quickly, if someone is injured, how much time do they have to start this process? And does it depend upon the type of injury?
It depends upon the type of defendant, essentially. Generally speaking, if it's an individual in California, the statute of limitations are 2 years for personal injury. Mm-hmm. If it's a government entity, so for example, if somebody trips and falls on the sidewalk and you want to sue the city, you have up to 6 months to call what's called the government claim. If you have to file that within 6 months. If you don't file that within 6 months, you've essentially waived your claim against that government entity. Following filing that 6 months, following filing the claim within that 6 months, the government entity has a certain period of time to respond. If they respond and they reject your claim, that triggers another 6 month statute of limitations. If they don't reject your claim, then you essentially have until 2 years to file your claim, to file your lawsuit against them. So it's pretty shortened with the government claim. Our policies are get that claim filed and get that lawsuit filed as soon as possible when we're able to, so that we don't leave any ambiguity as to statute of limitations.
Gotcha. A lot of people, I think people are afraid of lawyers. They know that lawyers tend to charge a lot of money. But I think one of the things, and I imagine a lot of the people listening to this podcast are aware of this, but in case you're not, my understanding is nearly all injury attorneys will work basically no fee unless they get you a win, sort of a, I'm blanking on the word I want to use here, contingency fee. I'm assuming you guys work that way, in which case, why do people, is it just ignorance that they don't reach out sooner? Because if you want to get the ball rolling on these sorts of things, you want to get it moving fast. And it sounds like working with you guys would be the type of thing that would get that ball rolling quickly and take a lot of the pressure off of the individual. Is that right?
Absolutely. We work in a contingency, which means we only collect a percentage of the fees. As fees, we could collect whatever percentage of whatever we recover. If we don't recover anything from the client, we don't charge them anything. It is extremely important for clients to reach out to attorneys as soon as possible. In my experience, what's happened is insurance companies have become very wise. Their number one goal is to pay out $0 to everybody, including their own insured, because that's more money in their pocket. And they're trained, their adjusters are trained to make sure that they minimize the amount of money they pay out. They will ask people questions during statements that seem innocent, but will put you in a position which would damage your case or be harmful for your case. Moreover, clients don't necessarily, if they don't get medical treatment in a timely fashion, it really hurts the value of the case. Not to say that the person is not injured, but the defense will try and paint the picture that the client is not injured. That's why they didn't get treatment. I know many clients don't have insurance, health insurance. Many clients don't have the resources to pay for co-pays and deductible, and they're too scared to go get the medical treatment. As attorneys, we can help them find resources that will enable them to get the medical care that they need, so that they get back to health. You know, our goal is to get them back to where they were before the accident, if possible. And it's extremely important for them to get paid on all the injuries, and that's our number one goal.
Okay, that makes perfect sense. So we're talking there a little bit about premise liability. You talked about slipping and falling on like a government building and having a different statute of limitations and timeframes people have to work under. So let's talk about premise law for just a little bit, or premise liability. What are some of the ins and outs that people aren't aware of when it comes to slipping and falling? And does it matter if it's a government building versus a private building versus a building that's being rented by a business versus an individual's home?
With slip and fall cases, there are a lot more nuances than with a traditional auto accident case. Traditional auto accident case, you have, usually somebody's driving a car and they get hit from behind, a traditional rear ender. There's really no question who's at fault. But in a premise liability case or slip and fall, trip and fall cases, generally there's a question of liability. Is the store owner responsible? Is the owner of the premises responsible? Many people have this mindset that if I fall and injure myself on someone's property, they're automatically responsible for my bills. They're responsible to compensate me. Unfortunately, the law doesn't say that at all. The law says that the defendant has a duty to make the space safe and secure, essentially. And depending on the circumstances where they are, they have an active duty to check and inspect to make sure that the areas are safe. If they fail to do so, then we have liability established. So that's one of the most important things. And that goes for government entities, a city, or if they are in the market. And the basic concept is that the entity has to be put on notice, which means they have to know that the dangerous condition exists. Either they've actively been told that there's a dangerous condition and they failed to do something about it, or they haven't bothered to go check to see the area to make sure it's safe in a certain period of time. And that would make them, again, responsible. And that's called constructive notice. They should have gone and checked. So these are the little nuances that we have to deal with in premise liability cases. And unfortunately, most cases in the scenarios don't resolve before filing a lawsuit. And the reason being is because you're dealing with big entities, big corporations who do not want to just succumb and pay. And oftentimes they don't have insurance. When you're suing a city doesn't have an insurance policy for everybody. They pay out of pocket. A lot of the big box retailers don't have insurance either. They actually pay out of pocket. So they will do whatever they can to not pay out of pocket, and they will put up a fight, including forcing you to file a lawsuit and pursue the case through the lawsuit until you can get a result from them, until you can get them to pay money. And that's what we do. We are heavy litigators. We will file lawsuits. We will do whatever is necessary. And if they're not willing to pay, we'll take the case to trial and have a jury decide how much they're supposed to pay.
Gotcha. Another question somebody actually asked me the other day, and I didn't have it written down, but I'm gonna pitch you this one too, and just see what you think. what safeguards are there in place? So obviously, if people are hurt because of the ignorance of a company, the negligence of a company, it makes sense to make sure that they're taken care of. I'm sure that there are times that people commit would be essentially insurance fraud, or they fraudulently try and hurt or slip and fall. Are there safeguards in the process? Is that just what comes out in the trial? How does a business, not that I want to stop you from getting business, but how does a business protect themselves from these sorts of issues?
Honestly, we're in the digital age. Everywhere, every business these days has cameras. There's cameras everywhere. And what they'll do is they're going to look at the video footage. And it's kind of clear when someone's fraudulently slipping and falling. And we've had a couple occasions where clients will come and they will make it up. And the defense counsel will show us video showing that our client, didn't fall. They actually saw the dangerous condition. They walked intentionally into it to injure themselves. And, once we get that video footage, we don't prosecute that case any further. We let the defense insurance know that we're not going to represent this client anymore because we're not in the business of committing fraud. So really, the owners have video cameras to protect themselves. One key thing that most people don't know, though, is that video footage is integral to your case. So if you were at a market and you slipped and fell and you injured yourself, you want to have that video footage because that's going to be evidence as part of your case. However, as with most things, video footage doesn't last forever. It gets erased after usually about 30 days. Some places even less. They erase after 2 weeks. So what's important is that you need to put them on notice to not destroy that evidence. And that's one of the reasons why it's extremely important that people that have those injuries hire an attorney so that attorney can get out what we call letter of preservation to make sure that they don't destroy that video footage before it's too late. And usually I say, if somebody's in an injury, if you don't get an attorney within the first 30 days of that slip and fall or trip and fall, you very likely have limited your ability to recover anything from the case. So I urge anybody that's ever had an injury in that scenario, contact attorneys so they can get that letter out as soon as possible.
That's important. And again, it comes with being proactive. The nice thing about working with an attorney, particularly in the personal injury space, is again, usually you can talk to them, get a free consultation, and they'll get the ball rolling. If they think you have a case, they'll help you take care of almost all of these things. So I always tell people, and again, it's the tagline of our show is, if you don't know your rights, you don't have any. So always be talking to a competent attorney in whatever field you're in, but in this case, obviously injury law. So, Sam, what's a common misconception people have about your line of work, being an injury attorney? I know that there's pejoratives and stereotypes too, but what's one of the biggest misconceptions or myths that you deal with on a regular basis?
I mean, the obvious concept that we're ambulance chaser is that we're just trying to make a buck off our client, and I'm sure there are plenty of attorneys that are like that, but we're clearly, hopefully, not like that. Our number one job is to get our client compensation, and our reward is obviously the financial reward, but it's to see our client have their compensation, they have their day in court, they get what they need. So I think that's the biggest misconception. And though there are the bad apples out there, as in any business, I think most personal injury attorneys are there to get their clients their rights, get them what they deserve.
Gotcha. That makes sense. And the ambulance chaser is the pejorative that I had in mind. A lot of people will call you that. I know there's actually laws and rules that regulate how you can even get in front of clients in the first place too, if I'm not mistaken.
And I'll tell you, I recently read an article as to why this conception, the ambulance chaser conception came about, is that generally speaking, it's kind of frowned upon for attorneys to advertise. Mm-hmm. And one of the first few attorneys to advertise were personal injury attorneys. So they would put their billboards up, they would advertise on TV and radio. And that's what kind of got the concept of ambulance chasers in people's head, because they were advertising. Now it's become very common for all attorneys to advertise to get business. And I think that unfortunately that negative connotation is stuck with personal injury attorneys, even though I don't think it's valid these days.
Gotcha. Yeah, as somebody as a marketer by trade myself, I've always found it odd that the rules ever would have been you can't advertise what you do, specifically because if you can't tell people what you do, then how are people even know to come to you in the first place? So I've always found that kind of a weird thing. And again, that's one of the reasons I'm aware of that, that kind of pejorative understanding. But I think you're right. And again, it really comes down to justice. At the end of the day, your job, if you're doing it well, as an injury attorney, is justice. Your job is making sure that people who are hurt through no fault of their own are getting taken care of. And I think that that's a noble pursuit. I mean, it really is. There's a lot of expense. And again, you take on a risk when you take on a client and you say, you don't pay me anything unless we win. There's hours of paperwork and research and everything else that goes into that, that you have to eat that cost if the case does go nowhere. So I for one, totally agree, and I'm on board. So let's talk just for a minute though. Fortunately for you guys, you seem to be very efficient. You have a 99% win rate. How difficult is that to maintain a 99% win rate, and what goes into maintaining that?
Well, the first is we won't take on a case that doesn't have value or merit. That's truly what it is. I will not lead a client down the wrong path saying, oh, let's sign you up, let's see what we can do with the case, and then just get them wrong results or get them no results. We'll let the client know candidly right off the bat, this is what we can do for you in a case. This is where we're going to go. And if the client doesn't have a case, we'll let them know right off the bat. We don't believe you have a case. Unfortunately, we won't be able to help them out. They may go to other attorneys and may also have those situations. But we are pretty good at vetting out those cases, making sure that we don't lead the client down the wrong path. Other than that, we're pretty diligent on prosecution of our cases. We're fortunately a full service firm. We do everything from A to Z, meaning we litigate, we do everything before litigation, and we have the ammunition that we need to prosecute the cases to the full extent, which is basically taking the cases to trial. Fortunately, almost all cases these days seem to resolve, not because client insurance companies want to pay out, but because we put them in a position where they realize that they either have to pay or let a jury decide how much they're going to pay. And really the trick to any case, personal injury case, is for everyone to understand what the value of the case is, what you're entitled to under California law. And under California law, you're generally entitled to your past and future medical bills, your past and future loss of earnings, and what we call pain and suffering. And if everyone does their due diligence on a case, whether it's ourselves or defense, you come up to a range of what the value of the case is going to be. And once you get to that point, there's no reason why the case shouldn't resolve. You'd have to be very unreasonable on either side not to make the case resolve. And those are the situations where we let the jury decide.
Gotcha. I pulled up for our viewers. If you're watching this on the video, this is actually some of their client testimonials. You can see some of the settlements that they've won. They have a host of videos here from people that they've helped as well. And then here's just some of their many 5-star ratings as well. So again, you can get there by going to centuryparklawgroup.com. So 99% means you guys win a lot, and you're very judicious in the cases you take. I'm sure you've occasionally had an issue though, where you didn't win. Failure is something that's pretty natural to all of us. So Sam, is there a time that maybe you failed at least in some capacity, or something didn't work out the way you were expecting? And if so, what did you learn from that?
The failure, we've obviously taken on cases where it didn't come to result, hence the 1% there. And unfortunately, some of it's just luck. You take a case to a jury and the jury is not agreeable, or we have difference of opinion, and the judge has to decide. And sometimes you win, sometimes you lose. So we do have those cases often, including triple fault cases where they'll file a motion to try and dismiss the case because of those notice issues I discussed before. So those are the little things that we have. And unfortunately, it's kind of the nature of the business. It's the nature of life. We deal with it, but the main thing we do is we try and prevent it from happening by vetting the cases early on and having the right systems in place so that we don't miss any beats. We don't make any mistakes.
Gotcha. Well, what's the flip side then? What's one of your biggest successes that you're most proud of?
I think one of our biggest successes, and I don't look at it as a financial success, I look at it as we truly try and make our clients happy. And that really makes me happy. And when I say happy, I get justice for my clients. I get them the compensation that they deserve and they need. And that's really the victory. We have a lot of cases, but we don't we treat every case as if though it's the only case we have in our firm. We don't like to sideline our clients. We make sure they get all the treatment that they need. And I think relative to other firms, we're very overstaffed. And part of the reason why we're overstaffed is to make sure that the client gets everything that they need on their case. We're here, we're responsive. We have a lot of systems into place. We recently instituted a new system called Case Status, which allows all our clients to download an app on their phone to get status on what's going on in their case. So they don't need to call us and say, hey, what happened with my file? They can just open their app, and it's kind of like a dominoes tracker, and it tells them exactly where they are in their case, what's going on. And if they have any questions, depending on who's handling their file within that portal, they can go ahead and contact our client. So I contact the attorney that's handling the case, or one of the assistants that's handling the case. So I'm pretty proud of the fact that we built a good system to really service our clients' needs at the end of the day.
Right. That's awesome. That's good stuff. You guys have a lot of 5-star ratings. You've had a lot of people that you've helped. And again, if there's anyone out there listening in the California area, I think you should definitely look into the Century Park Law Group if you have been injured. So I'm going to ask you a couple more questions here. We're going to go pause, do one more sponsor, and then come back. I'm going to ask you my magic wand question. But what's the best advice you can give to somebody who has been injured and they don't know if they have a case, they don't think they have a case, or they're pretty sure that they would just get shot down? Maybe they know the person that they were injured by wouldn't have insurance. At least they're pretty sure. Would you still say always check with an attorney?
I would say two things. First and foremost, always check with an attorney. I think that's vital because they're trained to know what to do and what your rights are. Mm-hmm. Secondly, I would also do your due diligence on the attorney you want to consult and hire at the end of the day. Many attorneys are a jack of all trades, and they may do personal injury, but they don't specialize in personal injury. And they may not know certain laws or certain nuances. They can make a huge difference in your case, whether you can prevail in your case or not, or what the value of your case would be. So I would say definitely, without a doubt, as soon as possible, consult an attorney. And moreover, do your due diligence, do the research, make sure the attorney that you're consulting or hiring is specialized in the field and knows what they're doing.
Just muted myself. I was pulling up some more of your reviews there. I think the tab just crashed on me. That's okay. All right. Well, here in a minute, I'm going to ask you the magic wand question. I want to know what you would change in the law, if you could, something that affects you or affects your clients. But first, I'm going to go read from our second sponsor today. And of course, that is Rocket SEO from Hundreds of Customers. Are you a business owner who knows that being on page 1 of Google is important, but you're afraid to work with a company that does SEO because you know that SEO can be very expensive and very slow? Well, not anymore. With Rocket SEO from Hundreds of Customers, we can force you to page 1 of Google safely and legally through the power of the news media. Rocket SEO utilizes national news media campaigns across a gamut of industry-leading sites that rank instantly in Google. You can boost your website's rankings in Google in 1 week or less with a simple system that leverages the power of major media companies and network affiliates of ABC, NBC, CBS, and Fox, as well as major news sites from the Boston Herald to the Sacramento Bee and all stops in between across the United States to put you on page 1 of Google in under a week, oftentimes 2 or 3 times on page 1 and many times for dozens of keywords per campaign. For more information, visit hundradsofcustomers.com/rocket. That's hundradsofcustomers.com/rocket, or email press@hundradsofcustomers.com. All right. Well, Sam, one of the questions I like to ask people, I'm sure you deal with frustrations on a regular basis. You deal with frustrations in the law. You maybe butt heads with people. There's certain facets of the law that are more frustrating than others. If you were given a magic wand and you could just wave it and change something that affects either you directly or affects your clients on a regular basis, what would you change in the law?
I would change the limits of insurance policies in California. The minimum policy requirements of California are 1530 policies that we discussed before. Mm-hmm. And these laws were created 30, 40 years ago. That is outdated. It's nowhere near enough money to compensate anyone on even a basic claim, let alone someone that has a high injury. Other states have increased their limits, and I think California needs to also do the same thing. I think there should be a minimum of a $50,000 limit that everyone's required to have, if not more. That would be the main change.
Do you think it would make sense to tie that to inflation, so that as the inflation goes up, the policy goes up, and just make it a standard that insurance companies have to adjust? Or, I'm trying to figure out what the actual solution would be, just out of curiosity, if you have any thoughts.
I mean, I think that would be probably ideal, at least with the cost of living or with inflation, for it to go up. I don't know how legislatures would implement a system to that effect, but at the minimum, I think the legislation should every 5 to 10 years review the law and update the numbers to fairly protect the public, essentially. And I think they haven't done so right now.
Gotcha. Yeah, I guess if it was a regularly visited issue, that would solve the problem. I guess when you said, changing the limits, my thought was, well, then in 15, 20 years, we run into the same problem again. If it was tied to inflation, maybe that would fix it. But again, if they would just stay on top of it and do the thing they need to do to take care of their constituents, that would probably solve the problem as well. So, well, Sam, I've really enjoyed this conversation. I feel like I've actually learned a little bit more that I didn't know about injury law, which is always a good thing. Before we go, I want to give you the last word. Are there any thoughts, comments, or questions that you think I should have asked, or any thoughts or comments that you'd like our listeners to know?
I think we've covered a lot of it. I think the key is that, what your podcast is. I think everyone needs to know their rights. And one of the biggest problems that we encounter, a lot of clients come to us too late, and they've given up their rights. So I think the key message that I want to get across to everyone is, if you're injured, contact your attorney. Contact an attorney as soon as possible. Make sure you protect your rights, because even 1 to 2 weeks of not contacting an attorney and not prosecuting your claim properly could make a drastic impact on your ability to recover your fair amount, which you're entitled to. So that's really the message I want to get across to everyone. Even if you don't want to hire an attorney, most attorneys are ready to consult with you. Just at least contact them, get information, get the education, and do your research.
And I think that applies to every facet of the law too. Again, if you don't know your rights, you don't have any. So the point of this podcast is to empower people to know that there's a solution out there, that there are people that are experts in this field who can take care of them if they have a problem. We've talked to, estate law attorneys and employment law attorneys and all sorts of different aspects, but it also comes down to your personal life. If you are injured, that can affect your ability to, live the rest of your life. If you're permanently disabled, you may not be able to hold a job again. And that's where talking to an attorney can really help you out, but you have to act quickly. All states, it doesn't matter where you are, have statutes limitations that limit how long you have to get an attorney or to seek restitution, to seek compensation for your injury. And you need to get the ball rolling on that quickly. The good news is, as much work as there is to get the ball rolling, there's also attorneys out there that take care of that for you, basically soup to nuts, as they say, right? And I know, Sam, that your law firm is one of those law firms where if they have a case, you guys probably do just about everything that you can for the injured individual. Is that right?
That's right. We do.
It's almost like having a law firm as your concierge or your butler to take care of you and make sure that you're taken care of. So, well, I've been talking with Sam Tabibian, and Sam, I've had a great conversation today. Again, I think I learned a lot. And again, as a reminder to our listeners, you can find Sam online by going over to centuryparklawgroup.com. They have lots of results on their results page. They also have client testimonials and various case results. You can see all of the success that they've had. And again, they have an incredibly significantly high win rate, 99% success rate. So if they're willing to take your case, that means they probably think you have a good case. I would highly, highly recommend anyone injured in the California area reach out to Sam and his law group, because I think you're going to get taken care of very well. And again, if you don't know your rights, you don't have any. This is Justin West, and you've been listening to The Attorney Post. You can find us online at theattorneypost.com. As always, you can also find us on all of our main channels. We're on YouTube, we're on Apple Podcasts, we're on Spotify, we're on Stitcher, we're on Amazon, we're on all of them. You can find us basically anywhere you can find podcasts. It always helps us if you leave a like, a comment, or you subscribe. So if you can do that as well, we would appreciate it. Until next time, we'll see you guys later. And Sam, thank you again very much for being with us today.
Thank you all. It's a pleasure.
All right. Bye-bye, guys.